Use mic, sir.
Well, the petitioner was a school teacher of a high school Dalmia Nagar Rohtas, established by an industries Rohtas Industries, the as science teacher by the then governing body of the school, my lord. Then in the year 2000, in the year 1976, he made a request to the school to allow him to join the industry. Then he was accorded permission, and then he joined there. Later he wanted to come back to the school, which was though allowed by the managing committee, but he was not allowed by the state government, because by that time the state
No, how did you enter the industry?
Obliged.
Rohtas Industries.
Rohtas, it was the Rohtas Industries
You entered as what?
as an employee of the Rohtas Industries, my lord,
Correct.
not as a teacher.
Huh?
Not as a teacher.
Then how are you entitled to come back as a teacher?
My lord, my lien remained intact, my lord.
How can that is the reason? What is by what method you have gone to the Rohtas Industries?
My lord,
Is it on deputation?
my lord, I have given the list of dates.
Sir, I am asking you, were you on deputation from the? Then were you appointed directly in the joint Rohtas Industries?
No, my lord.
Then how did you join? Simply just walking to the industry and your services, you have been your duty has been accepted.
Yes,
What is
madam.
whether were you appointed on direct recruitment or a deputation, appointment by transfer? What is the method?
My lord, I requested the management to allow me to join Rohtas
Sir, how
Industries.
can you? Shall I go and ask the industry? Please allow me to.
No,
accept
the
my duty report?
industry accepted me,
Hmm.
and they allowed me, and they got,
You have worked up to what date?
up to. In the meantime, I wanted to come back, but I was not
To
allowed.
what date you
till,
have worked?
till I superannuated there.
Then you are not entitled. You are not entitled.
My lord, in the meantime, my lord, when I wanted to come back, then when I was not allowed, I filed a writ petition, that is annexure 6 to the earlier to the writ petition, my
Sir,
lord.
first of all, you are not able to understand this code that you had a lien. Under which law you have a lien over the education department?
The managing committee accepted that you retain the lien, my lord. That
Huh?
is the
What that is? That is
the managing director itself managing committee itself accepted that he had a lien.
correct without consulting the government.
The government
Where is the government permission or the competent
Because
authority approving your lien?
when I gone there as an employee,
You are not
at that
entitled,
point
sir.
of time it was not taken over by the government. The government says
What is the date of joining Rohtas Industries?
1976, my lord.
1976. You retired on?
I wanted to return, but I was not
No,
allowed
sir.
to.
What is the date of your retirement in industry?
Retirement 1997.
1997.
Yeah.
What is the date of filing writ petition?
The writ petition was filed. Earlier writ petition was filed in 2005, my lord.
What happened to that?
That is annexure 6 to my writ petition, my
Correct.
lord.
What happened?
Yes, my lord. They say that pay him the admitted dues and rest disputed amount may be settled
That's all.
by the
Not-
government.
Not in
Then
respect of,
by the next day, but the government rejected the claim of my retirement benefits and others, including
you are not
pension.
entitled, sir.
Now,
Please
can you
take
see by the impugned judgment, the honorable single judge has not decided the list. They have
No, he
simply
need not, because you are not given the information by what method you have gone to the industries. Direct recruitment, appointment by transfer or deputation. Your father-in-law was managing director.
not.
Then how your duty report was accepted
No,
by
this
industries?
the school was opened by the industry itself. Then
So, management, there was a collusion between management committee and yourself. That's all.
my lord, may I read that impugned judgment, my lord? That will throw some light. What was the grievance?
Sir,
here?
first of all, you don't have lien. Unless you have a lien. You don't know
No,
by
I
what method you have gone to the industries.
I being the government servant,
Sir,
aided,
you are not a government servant.
No,
you are an employee of an education institute, aided
aided by, yes, my lord.
correct.
And-
Now the Rohtas Industries is a private industry.
Yes.
Then where is the question of transferring a aided employee to a private industry, and further having a lien in the aided institution? Please take up.
I'm sorry.
In the instant appellant has assigned the order of the learned single judge dated 6/7/2018 passed in CWJC 13505 of 2012. The appellant was stated to have been appointed as a teacher in an aided institution in the year 1976.
1955, my lord. 55. I was appointed in 1955. I served there.
In the year 1965.
List of dates is given in the
First up,
LP itself.
the aided institution in which he was working were having industries at Rohtas Industries. Full stop. The management, with the consent of the appellant services have been taken to the Rohtas Industries, and he has worked there from 1976 till his attaining age of superannuation in the year 1997. Full stop. In this backdrop, the appellant intends to return to the aided institution as a teacher. Full stop. Such a relief has not been extended to him by the authorities or by this court, so as to extend service and monetary benefits as if he is an aided employee by the state government. Full stop. He had certain grievances in the year 2005, which was decided, leaving open certain issues. Full stop. The state government has rejected the appellant's claim relating to extending service benefits as if he has retired as a teacher in an aided institution.
Later taken over, my lord. It was later taken.
Full stop. Within bracket, the state government is stated to have taken over on what date?
1980.
210
1980. 1980. 1980.
980. 1980.
Yes, my lord.
Within bracket, taken over on 210/1980. Full stop.
And
It is to be-
in between retirement, my lord,
It is to be noted that in next paragraph, it is to be noted that the appellant had a cause of action in the year 1980, as on 210/1980, the date on which the aided institution was taken over by the state government. Full stop. State government, while taking over the aided institution, must have imposed certain conditions relating to taking over the institution along with the men and material. Full stop. As on 210/1980, the appellant was not in the aided institution as he was working in Rohtas Industries. Full stop. The appellant has not questioned the condition imposed in the taking over the institution on 210/1980. Further, he should have approached a judicial forum in seeking a return of his service as a teacher in the aided institution or state government taking over such a institution. Full stop. On the other hand, he has completed his service till age of superannuation in the Rohtas Industries.
Though I have been repeatedly
Full stop.
asking to come back.
All right. In the light of these facts and circumstances, the appellant could not apprise this court as to by which law he has been taken, his services were taken in Rohtas Industries, and further, no provision of law has been pointed out that he had a lien in the aided institution, so as to examine whether the appellant is entitled to have a lien over the teacher post in an aided institution and seeking further service benefits. Full stop. In the light of these facts and circumstances, full stop. Next paragraph. Even the conduct of the petitioner is required to be taken into consideration for examining the petitioner appellant's claim. Full stop. In the year 1976, he has gone and worked in Rohtas Industries till attaining age of superannuation. Full stop. He has retired in the year 1997.
1997.
97. In the meanwhile, the aforesaid aided institution was taken over by the state government on 210/1980. Full stop. Further, he has taken 8 years to approach this court with a certain relief. Full stop. Thereafter, once again he has filed CWJC 13505 of 2012 in the year 2012. Full stop. In view of these facts and circumstances, there is no infirmity in the order of the learned single judge did it so and so. Accordingly, appeal stands dismissed.